And Simon Minoka say, documents number about say 49 pages. Oh, make come me Akosua Serwaa one man or the bone in the bush penny coffee so. Or more court in Semi. Final judgment. No. Copy aba. Unya. And the higher gossips 24. And you're far from breakdown at the Bremo on Friday, 28th of November. No. Name way. An analytical. Come above for the Yakim. An analytical piece by Gossips 24 based on 1 or 2B. I just say, I come across in the final judgment. I hear Gossips 24. It's Mr. You might be able to lens in the tonche. Na you might be Akosua Serwaa lens in the tonche. Natural way from Gossips 24's point of view. Mama, there's also been a subscribe button, so now I click the notification icon. So now make a photo tap send. And I Mr. Mo send this car. Oh, share video from Germany, from USA, from Canada, from Australia, from UK, and I say Europe will be a tap send the number 1. Reference code I'll bet me easy or tap send. So J24, as simple as ABCD. J24. Fasten this car. Tap send. So now back to command. So you know, like I said earlier, your brain will break down of the entire judgment. Yeah, the Bremo on Friday, 28th of November 2025. Let me check out that episode. It talks about every single thing that was captured in this judgment. But what we are about to do here today, you know, I say about the judgment because you know the fundamental of this whole case based on the marriage certificate. So why didn't the judge admit the marriage certificate that was presented in court? I didn't know judge Anjiantu. And that takes us to page 88. I just say, the marriage certificate, I just say, and no evidence in chief. Now, evidence in chief, a man no more tender no ino. Objective. I just say, a learned council of Mami Odobuni and an objective. Now, more objective, you know, it was on the 28th of October 2025. Assembly so boy on the 28th of November 2025. It's a judge, and they say, sir, objection, no, because defendants no lawyers same kwai o ma fa so this certificate to ababetui ekotia evidences act no ekotia it is a court ni gitum a enye ye it you no judge ne say e surprising say lawyer Kusi into me and comply with the requirements nearly a month later because omutie interlocutory injunction on the 28th of October sa da no and a defendant in the council a raise objection. And the judge in paragraph 89 said, Section 6 of Evidences Act no echimu say, so obey the evidence eba edietiawa. Nasa who raise objection. As objection make sure so be raise no. Our timer ye the evidence ni be PM or court. Enti onu judge ni taking note say, Mami Odobuni lawyers no. Omu raise objection over marriage certificate no. At the time, I know Moka interlocutory injunction, so they were on time. But I surprise say, as much as the defendants and lawyers no were on time, no lawyer Kusi ain't to me and follow requirements, no. Even after a month, and that's nearly a month, when to me and follow. And no judge in Babeka or paragraph 89, Honomoa say, Se courts no, etsi Honomoa, courts no dear. The ombetu me and say ombetu me consider. No, my evaluated documents and say, indeed, documents where you to my ye and now say ye, and they are court in the Juma Sombe. So it means that as much as say, lawyer could see where Juma say obey meeting requirements. No, courts in this way Juma say, on bet check say documents where you to my ye and now say ye. Now, me say, take this from an analytical point of view. Say lawyers no role or mo play, say so na court no ewo role or me play. Say ye beji certificate na tum and now say ye engine tum. Now judge ni ba be chire mu ha say or share exhibits B and B1 no almost say a marriage certificate and a translated copy no. So exhibits B and a marriage certificate no and a B1 a translated copy of the marriage certificate almost by 2 courts in the name no. Defendants in the council e can say massa Sadi way ya jitu mwenye yi. And then they say a marriage certificate. A lack authentication. A lack proper certification. Foreign documents, you know. Ya wambra o honma ya digitum. I just said only a section 161 of the Evidences Act. Section 161 of the Evidence Act. You know what walk it through. There were 3 subsections. Subsection 1 no. Say about signature no. Say signature no. And pass if office dimu and say ampa. Na say a foreign documenter. Nasa Ghana recognizes her or mine or mumra ni adia. That means a Ghana be what embassy wo hointi. Se Ghana wo embassy wo ha. Or se Ghana embassy na was our mine so. E de stamp esi so anaso mo de bibi krata bi ka ho. What I say? Nature sampa. Sa document we recognize mujitum wo Ghana eyiye. Eno danche no section 3 no essay say yema opportunity say fa yes adie we na documents ni enye authentic na be away to me na but ubo homode a omo say the court may for good cause shown just say effort order that it be treated as presumptively authentic without certification. But ono judge na ka or section paragraph 91 said sign number way nyina no plaintiff no ayama me Akosua Serwaa a lawyer no entumi emiti. Page 18 omo written address by the plaintiff che say ewo ho no mo ene ade a omo church certificate ni mu ni ade. But lawyer Kuseka omo say omo hardship in meeting the statutory demands of section 161 of the Evidences Act subsection 2 no lawyer Kuseka kire omo so omo practical hardship a omo face. But edu interrogations no first question omo bisa no answer no kire say omo nsaka authentic marriage certificate no it judge no dey ote ho no mo o twen say omo the authentic marriage certificate no ebebe kire ni. Now, o taking notes, so beka me bon papa bi di che Richard Oparida ako. Me bon di che so ye ade bi ma judge ne say ade no ye no o mana kosa but ade no ye no who kwan so ye. Judge ne say this interrogatory was answered by Richard Oparida ako. Oye plaintiff no clerk to the plaintiff solicitors. In this case no ye ma Emma lawyer kusi. Just say Richard Oparida ako no onye fit so be because mami Akosua Serwaa and the power of attorney, I'm a Mammy Georgina. It will be what was I, sir. I was a Mammy Georgina, and yes, sir. It is a Richard Oparida and a yes, sir. By Richard Oparida and a yes, sir. Into no judge, no. As is hard, the dear. And you know, quite so no. A untruth answers and or supply, you know. It is a I didn't Richard Oparida, you know, so jitu mua, and ye say a certified document, no. Into your cancer law clerks and desist from such unlawful acts. And no judge no ebebe chemo burden of my friend is a proof and after evidential burden of proof no be chemu chemo earlier say biasa me kasa wo ye me area or say me prove is am pama ye ho ade me to the videos aba say you worry ye twa pictures wa say you worry ye say me kasa ya worry na o marriage certificate or say me the evidence ba say am pama worry na marriage certificate na e wo ho sa evidential burden of proof no and na judge no age na so na judge no age na so no na oba paragraph 93 aba be kase tio se plaintiff no attempt say obe certify German marriage certificate na at least obe to me as submit evidence of such attempt say bia ye call German embassy you na actual letter the mom date say but omo respond here and no and na subsection 3 of Evidences Act 161 no section 161 subsection 3 no and no na can say the court may for good cause shown into lawyer judge na come say senko mu show good cause and e bia omo letter bi omo twede come Ghana embassy e wo Germany say bi omo attempt certification ni mpo and ka subsection 3 of section 161 of the Evidences Act nko no judge ni be gina so dia bo mo. But ono judge ne say, ono judge ne say, besides her lack of certification and as authentication, no, na or she have lawyer could see so bet me the original certificates, no, abra court, no. However, the other buyer, no, a family diary. Just ono lawyer could see na kasa jitu mo, or open courts away a family book, and as a family diary. And a document no so edibuy no. On the judge no extra, just a copy of exhibit B ni bi no lawyer kusino edibuy. Nti on to me jintum say marriage certificate. And on the judge no kan ya be see point 96 cover Evidences Act section 136 of Evidences Act no kasa about authentication no ebuy. Essence lawyer kusika say omo original marriage certificate no omo no buy no admit say no na if family book mu na ye extract ni ade no na foreign signatures has was no now I expect some be follow section 161 no omo follow no but omo follow Into no mutumi omo admitia enye ye. Judge number beka was paragraph 98 say or expect says her exhibit B no at least a be free a registrar of the civil office Burnham marriage registry no e be free omo hono na say free omo hono mu ewie a obi a Ghana embassy e Germany a certifying na certification no aba ebebedu court n'anim ansa na court no ebetumi a consider. Now without no court no to me consider court no be assume say wo fa bibia amembe to court no enim. Court need to me consider. Na mama ye na sina fosu enkomo mu ni di wo court on which me catch on say mama ye na sina kira no obi na dad Lumba ni mama Akosua Serwaa eware ni ade na later we make say mama Georgina Nkwana na ejina ho enti no omo adanse omu di ye no conflict in there but ono judge no expect say answers no omo de ma ye ni enti no obehu okan paragraph 100 say nko obehu mama Akosua Serwaa dad Lumba signatures our marriage certificate no eso na pictures no hwe there na ampa dad Lumba any mama Akosua Serwaa sign ne krata bi enti ko at least nko obehu say marriage certificate no so no omo signatures also. But in the absence of such signatures on the marriage certificate no, at least in can say lawyer could say to me expert witness or say in the alternative the absence of such signatures on the marriage certificates from Germany should have been affirmed by an expert witness. However, expert witness obe jina court hono no na obe traditional marriage. Now pay attention to paragraph 101. It tells you the judge the thought process towards admitting the certificate, the marriage certificate. It tells you a lot about judge the thought process. Judge say Ghana marriage certificate has the signatures of the couples and signatures of their witnesses. If the court is presuming German law to be the same as Ghana law, then same should be seen unless rebutted, which was not done in the instant case. Judge say you presume say German law ne Ghana law pe. And you are no judge no ebe assume say okay say Ghana has say no marriage certificates baby na we hu no. Omo mo ware no any of witnesses signatures also. It's at least Germany mremu so no. Marriage certificate no expected do be hu no. Omo mo ware any omo mo ya dance for no omo signatures ebe also. Na sente sa so a enke wo say rebuttal eba say my lord and I say my lady ente sa e Germany ho but bibiamba in that case or say if the court is presuming German law to be the same as Ghana law, then same should be seen unless rebutted, which was not done in the instant case. Inti me no mo interlocutory hearing no odobuni lawyers objecting certificate no its admissibility. Throughout the case there was no rebuttal. Sana judge ne person chewa asi said there was no rebuttal to that effect. Into no as you say Germany man Ghana my pair and they also who signatures ni bia also. But entisa our Germany ho. Entisa. Now, this also can be on paragraph 101 say. Hence, what was presented to the court cannot be the marriage certificate. It has already been said that what was presented is an extract or a record of registry in Germany without any explanation. So because there was no explanation, the judge assumed that if Ghana law is the same as German law, then I have to see signatures on the certificate, right? The judge also assumed a lot of things because there was no explanation. Judge in the same. It is the more reason that the document should have been authenticated and the signature identified and certified as required by the Evidences Act. But this is where it gets interesting. Now, remember, that's why I said take the lens of Mami Akosua Serwaa aside, take the lens of Odoboni aside, and look at this case from an analytical point of view. Remember, say, our paragraph 89, which the judge referred to section 6 of the Evidences Act. Or can we say it must be stated that the court is duty bound to consider and evaluate. To evaluate means that as much as you think, say, German law and Ghana law are the same, you are going to see what is the format for German marriage certificates? Because if Section 6 of the Evidences Act, no, that's a judge Nakasaka paragraph 89 of the ruling say it must be stated that the court is duty bound to consider and evaluate any document. That means the court shouldn't presume after its evaluation. But the judge presumed. And the judge, it's a suka wahanum say, it's a presumption into and no meant to me and the documents not to. Because there was also no proper explanation. However, in paragraph 102, judge, I want the judgment say, documents, right? It is seen attached to Exhibit C. Exhibit C a letter from German consulate, what Ghana, buy a letter and the date was 27th of October 2025. Sa letter na judge ne eka say, sa Exhibit C on the last paragraph I see attached you find a copy of the said marriage certificate for your perusal. And the judge eka say, those are letter every German embassy what Ghana has say. And na eba the same document as Exhibit B. Now remember, say Exhibit B and a marriage certificate na judge and say a copy. Omudi be about say extract. And the judge neka paragraph 102 said, but sa documents attached to Exhibit C the same as Exhibit B. It has a different signature and date. Now I said, look at the thought process also of the judge. Or say the document is signed by Gays Standards Bimta. Moye Germans no munim how to pronounce this word better. It's judge and say sub documents are signed by Gays Standards Bimta, dated 23rd October 2025. It's important to pay attention to this part of the conversation, right? Judge ne to asubium ekai paragraph 102 in the extension say Exhibit B supposedly the marriage certificates has the signature of one Beckham Standards Bimpton, dated 12 August 2025. The two documents look similar. See, judge ne say, the documents be attached Exhibit C. More can say a marriage certificate. Sir, documents somebody attach Exhibit C. Inipa ni signature was your friend Gates Standards Bimta. As Hanipano or sign it on the 23rd of October 2025. Remember, says letter me say date was 27th of October 2025. It is a letter me do German embassy and a German embassy sa certificate me do German embassy and a German embassy letter ne count and a Akosua back court. Right, good. And now judge no can say, but sir certificate na attached to sa letter similar to Exhibit B. Now Exhibit B ne there inipa ne signature was here Beckham Standards Bimpton. No sign here on the 12th of August 2025. Judge ne jitu say sa document be no look similar. It was similar information, but there is no explanation as to why what different signatures and dates. And the court has not been given any explanation as to what exactly Exhibit B is, since what was brought as the original was said to be an extract. And even if it is the marriage certificate, same cannot be relied on by the court as they were not authenticated or identified and certified, contrary to Section 136 and 161 of the Evidences Act. Now, what is the judge's thought process here? Pay attention. The judge's thought process here and they say, Gates Standards Bimta, right? Or signing here on the 23rd of October 2025. No, enipa dini Gates Standards Bimta. Into your no judge no say until say Gates Standards Bimta no sign a document on the 23rd of October 2025. Now documents are Exhibit B one lawsuit in the mono. And no enipa or signing and Beckham Standards Bimpton. on the 12th of August 2025. Do you see what I'm seeing here? It means a judge in Nigeria say, why are two different people signing on different dates? No explanation has been given to her. But remember, so no judge Konaka says section 18 or paragraph 89 say it must be stated that the court is duty bound to consider and evaluate. So evaluation means that the judge or the court could have found out if indeed Gay Standards Bimta is a person. No. The word Standards Bimta and Standards Bempton are titles like registrar in German language, a Standards Bempton and that's a Standards Bimta. Say a Bema a Standards Bimta. Say Oba a Standards Bempton. Now, gays no or ye juma or born him registry honomo. Just say the full name a gays get the profile and that picture and that screen no. And now Betchem Standards Bempton no judge no. Right? Because she was not giving any explanation. No. Against or ye nipa no. Betchem Standards Bempton no HS Betchem or ye registrar Oba and sa Bempton ni profile and now who screen this way. Right? Oko website neswa oko born him for civil way no baby omo ya ware any ade registry no oko website and so now o search Bempton na obo say friend Catherine Betchem. Just or ye registrar. So what it means no any say documents mienu na ebaye no. At the time mama mi Akosua Serwaa eko German registry no born him honomo so akwa je marriage certificate e da ba file lawsuit and I said the ba chess and pada Lumba e ware no. Na Catherine Betchem and I say e born him honomo. Just say or sign man no or ye registry or ye adwuma or registry officer what born him. And then at the time I okoye so akwa je certificate na ba German embassy what Ghana no way to be the letter atoso sampa certificate we every year honomon. Na gays get and I just say ho at that time. But judge no interpreti say Stands Bimta no gays no edin but Stands Bimta no HS gays I just say or ye registrar. And the judge ne ba can say when ya any explanation obi antumi a cheche mu antre no why intia Gay Stands Bimta what document ba akoso now on another document no Betchem Stands Bimta obi a explain ya no. And so the question also is paragraph 89 no I can say court no duty bound so obey evaluate document no. Didn't they also evaluate the document by doing these searches? That's also another question you would ask. Instead of me say you mami odoboni lens to channel. So what she mami odoboni lens now? Then automatically you would say ade na lawyer could see and explain your function. But so she mami Akosua Serwaa so lens now. The question you would ask ade into na court no to me anya these basic searches. But only assume say Gay Stands Bimta nipa and after so Betchem Stands Bempton nipa adena nipa different and a sign here. But so call born him registry no right omo sign our documents ni ade na obehu say sankrofo we and omo ho no betumi assign our documents ni ade ama. So they are real people who work at the registry. However, someone was unable to explain in the court for the judge to understand, and the court was also unable to evaluate the document. But the onus here lies in whose responsibility it is to explain to the court so that it will be on record that I explained to the court. Because you don't expect, say, the judge should automatically understand. Though the judge has admitted that there is a duty for the court. But you don't expect, say, if you don't do yours, the judge automatically does hers. Though in administering justice, you would expect, say, why didn't they do that? You would expect, say, why didn't they do that? And that is why you and I are not judges. That's why you and I are not judges. So, because of the certificate, right? The certificate was annulled on these grounds. The certificates were annulled on these grounds. Say, judge, no, I admit, say, or presume it's a German law is the same as Ghana law. Ghana have a certificate, no, and nipa signing a omo witnesses so signature was to be. Oh, our Germany for the so obi an church be mu an no. Afesu no certificates no I free Germany buy. The omodi kai suit no exhibit B. The omodi aka letter ho di aba no. E di e wo exhibit B no any dey always no different. Obi an explain an no. Intike was saying at least obi explain it no. That's what I'm saying. Say instead of bringing an expert witness who is going to explain traditional marriage, you know, why not rather bring an expert witness who will be able to explain German civil marriages and how German certificates maybe tomorrow, maybe you and I in court. So we learn one or two things from this particular case. You understand? Because though the judge is admitting in paragraph 89 say the court is duty bound to consider and evaluate any document. The court, let's with the judge, presumed a lot of things. A lot of things were presumed. Because she is admitting, say, she wasn't giving any explanation. So if she's presuming, you can't blame her. Right? You can't. The law is interesting. You can't blame her if she's presuming. You can rather blame her if you explained and she refused to admit your explanation. That's when you can blame her. But if you don't explain, you can't blame her. So the final ruling, no, was that Odoboni and so yere. Mami Akosua Serwaa and that the Lumba so eware ewa mambre kwan so. Inti no mienu ina no no for the late Charles Kodiofoso. Inti consequential orders no and say kwan ebusua no enhwe. Some be recognize Mami Akosua Serwaa no Odoboni na so mo yere no. Inti Odoboni so ho kwan so no so ye kuna ne bia eyeye. Inti busuafo ne konkɔ ye de ese. Third defendant in the yeah, transition for no one can be unfound formal. Ebusia penny kofi wusu and no man access to the late Charles Kodiofoso emono. So uncle and conco ye costs any BBR wow wade assembly tia and higher gossips 24. But you may or comment section.